What a world. Bless you. Good morning, everybody. Welcome back to Law and Legitimacy. It's Tuesday. We were down yesterday because Mike apparently acquired the blue willy cold from his son, and now I'm sneezing in Connecticut. So go figure. Welcome back, Mike. How you feeling today?
I'm feeling a lot better, Norm. I'm feeling a lot better. Good morning, everybody. Good morning to you. How's the weather there in New Haven?
You know, it looks nice, bright, sunny. A little foreboding today. We have closing arguments in a murder case that I've been involved in for a few weeks. And there is, frankly, nothing like a murder case to remind you, no pun intended, of mortality. But just how sad and tragic life can become. The defense in this case is self-defense. A jury could. There's no question, obviously, that a person died. There's no question that the person died as a result of a gunshot. The question is whether the shot was justifiably fired as a way of protecting someone from physical violence. And that's what the jury will decide. And so, I approach the day with a sense of being happy to be alive, filled with wonder about the world and all it contains, but a heavy sense of responsibility leavened with something like dread, because there is just no good way to walk into a courtroom steeped in death, and have the family of the decedent on one side of the room snarling at the family of the accused on the other. In fact, once again, I've managed to make new friends. One of the decedent's relatives was barred from the courtroom for the rest of the trial after telling me off in the middle of a cross-examination. So we went into chambers and I said, Judge, I just really don't care to try this case under the threat of personal violence and having my you-know-what kicked. He said, well, can't say I blame you. What do you want us to do? You want a metal detector up here? And I'm like, nah, there's already one downstairs. So I'm back. We'll give closing arguments today. We'll either we'll probably get a verdict sometime this week, and I'll be happy to report it to you and the details of the case, because I know people love real court stories. On that topic, we're a few days out now from the Trump conviction. Regular viewers of the podcast of Law and Legitimacy noted some tension, they say, between Mike and I. Jim Nugent, an old friend, said, you guys need to get your stories straight. I said, no, I'm not so sure about that. I think we need to listen to one another. And I think we need to compare our viewpoints. I was walking down the street yesterday on my way to court, and somebody stopped me and said, you're Norm Pattis, aren't you? I said, well, yeah, most days. I've got a letter here that I'm going to send to Judge Juan Merchan. I said, yeah. I really need this before I go to court. Yeah, I want to tell him how disappointed I was in how he handled the case. And I said, well, it's funny you should say that. I thought he did a fine job, and it reminded me, Mike, of our disagreements last week. And I thought about it over the weekend. And, Mike, I think, tried to give me a compliment by calling me based. Of course, being an old man, I wasn't sure what that meant. But I did reach the following conclusion. I am an institutionalist, meaning I believe in supporting the institutions of the Democratic Republic, including the court. And therefore, I will be perhaps somewhat unreasonable from time to time in defending the conduct of judges. And I will certainly do everything in my power to educate people about legal process, about what actually goes on in a courtroom, its strengths and its weaknesses. Last week, Trump was convicted, and for some people, it was a source of glee. For others, it was a call to arms. Many people, I suspect, were indifferent to it. But look at that headline. 34 felonies Trump was convicted of. Say what you will about whether they were well-founded in fact and law. The appellate courts will have plenty to say about that. But $200 million since Election Day? What's up with that, Mike? What does that tell us?
I think so. I went on Laid Back Law on Friday at the invitation of Eric Hunley, and a number of people were in there. And I spent a great deal of time talking about mine and your discussions of late. I think it had been noticed already by Eric and Ian and a couple of other members of the panel, and I think our conversation on Friday was important, not just I think for you and I directly, but I can observe that it was important for a lot of our viewers just based on the comments that we got on that video. It's a really popular video. We're well over 1,000 views on that, 25 comments, over 100 likes, that kind of thing, and that's good traction. But many of the comments were some variety of a couple of things. It was how productive of a discussion it was, the fact that perhaps you are dyed in the wool Democrat or whatever, and maybe that's okay. But ultimately, I think the source of our uh, popularity with that video truly was our commitment to each other within the conversation. So Jim Nugent, I'm glad that he cares about mine and your interpersonal dynamics. Really, truly, I'm not. Sometimes I feel like people can mistake me for being sarcastic, and I'm not being that way. Um, but I do think it is our continued commitment to that conversation and being candid with one another, not necessarily just trying to win the argument, but actually getting somewhere with the
Yeah,
conversation
I think that's right.
that yields something really productive. And what I think this money raising for Trump in the aftermath of the conviction means is that you and I both have stable ground upon which to stand and lob our opinions on this issue. I think the what I spoke about on laid back law with respect to Trump is that this conviction has done little but further harden the base that is MAGA, that is the populist right. And I think that the populist right is perhaps old within that lexicon of political words and ideas. I do think something else is going on within that populist framework that is to the benefit of Trump. I talked about the fact that rap culture is now the domain of the political right, and you can see that by and through the cameos being made by various artists at in-person events and stuff like that, the shoe release, blah blah blah. But this $200 million raise, I think, sends a signal from those who are contributing to our political and elected betters that are staunchly anti-Trump. That he's not going to go down without the consensus, right, being behind him, right? That it's not going to
What does
wither.
that mean? Without the consensus being behind it? What's the
It's
consensus?
that where we go one, we go all kind of thing, right? You've seen that acronym all over social media, but it's the Three Musketeers thing, all for one for all kind of thing.
It's
Um,
also a QAnon phrase, right?
well,
So
all for one for all is not QAnon, but
no, but where we go
uh,
one, we go all,
right.
yeah.
But if I fancy myself D'Artagnan for a moment, I do think that there's something noble about that. Now, whether it's wise, long term, it remains to be seen. But one thing is really clear is that, those on. I want to bring up this video. I saw this.
Well, let me just round this out, the money piece. I mean, I am I a dyed-in-the-wool Democrat? I don't know what my politics are. Somebody asked the other day, and I said, "What?" I think I even said it here on the show. I happened to be in town hall paying my property tax the other day and noticed it was primary day, and so I went in to vote, figuring I was there. And somebody said, "What party are you?" And I said, "I have no idea." I thought I was an independent. Turns out I am a Democrat. I hadn't realized that, so I did vote. But I am becoming more and more disaffected um, with Trump and his supporters, and I think that in part it's because I don't understand the appeal of Donald Trump, and I don't understand. I'd like to see less of an attack on them. I'd like to see less vitriol. I'd like to see less ad hominem treatment of judges and political adversaries, and more of a discussion of how to build a better world. And I understand the anger of the populist right, and I share much of it. But when I see $200 million raised in the wake of 34 felony convictions, I have to acknowledge the power. that Trump has in the polling place and in the electorate at large. And I'm hungry for more information about the sources of that power. Before you
Well,
shift this panel, can I make one more isolated comment, Mike,
it's not
and then
shifting to
shut
the
up?
panel. It's literally about Trump. But yeah, go ahead. Make the shout out.
Smirkanish had Charlemagne the God, I think, on
Yep.
over the weekend to discuss the Trump vote. And Charlemagne noticed among many of his listeners an increased interest in Trump. One comment in particular stood out. Yeah, I know what it is to walk into a courtroom and have that system be against you. When they want you, they get you. You know, another listener said, you know, I like the guy because he doesn't like play me. He lets me know he's a real a-hole, but at least I know what I'm getting. And you know, it's not it's not that a majority of black voters, and these were people of color, I gather, that was the impression I got from Charlemagne. It's not that the black community has suddenly shifted to Trump, but some pollsters noticed that in the wake of the conviction, he might have picked up as many as 10 percentage points in the black community, which is a significant bump in a close election.
Yeah, and this is something I've been saying for a couple of years now. I mean, I've seen this trend, and I think, I give myself credit for being able to observe the truth of that. I don't know that it's necessarily new, and it's just because of the conviction. I think the conviction catalyzed a common recognition among people who are already thinking and seeing the same things to actually have some sort of collective response. What's interesting, this is Piers Morgan. It's a panel you can see there, Mr. Wonderful, and even Andrew, or sorry, the gentleman's name from the Daily Wire. Anyway, I'll let him speak for himself here for a moment. But this is the broader conversation, Norm. This is, I guess, a microcosm of the conversations that are occurring all over the country in public and in private. A minute and 41 seconds. I'll let this go for maybe it won't go the whole time, but I want to introduce this by saying this is the difficulty of the average person, especially a high-minded and reasonable person, to defend the conviction of Donald Trump, in particular, with these charges and these sets of facts and circumstances. I think this does a really great job of just exhibiting that in a brief moment. I'm going to play it.
My fellow panelist here is celebrating that the rule of law has been
That's Matt
vindicated
Walsh.
and overturned 234 years
No,
of
that's not
American
Matt
legal
Walsh.
tradition.
That's Andrew Clayton,
I
I
would
think.
challenge her to see
It's
if
not
she
Andrew
could
Clayton.
possibly
I'm an idiot.
articulate how and what crime Trump committed, because so far Alvin Bragg, the DA, has failed to do so.
Michael Knowles.
The judge in the case, Judge Merchan, has failed to do so. And they can't do it because Trump didn't commit any of the crimes for which he's been convicted.
Well, let's just ask quickly before I go to Kevin. Francesca, just on that point, what crime did Trump commit?
It was financial crimes. It was white collar crimes. That is exactly
Which
what
one,
they
though?
charged him. He was convicted on.
What was the crime?
It's New York state law.
I understand. What's the
Buying a
crime?
business record.
Francesca,
I don't even like it. It is
Well, hang on,
literally, he
Margot.
just got convicted on 34 counts.
Francesca, what was the crime?
Of like cooking the actual books.
What was the crime?
You are not allowed. So you are not allowed to use your own financial, like your own money, to pay off somebody, and then
This is why people should listen to Law and Legitimacy.
This is what I mean. This is what I mean, though.
This is why people should listen to Law and Legitimacy. He did commit a crime. The crime was falsifying a business record, period. Now, whether that was a felony or not, the appellate court will say whether the record was sufficient. But how can they assemble a panel for national television filled with such nitwits? How does that happen?
Well, Michael Knowles, I don't think, is a nitwit, right?
I don't think. Who is this woman on the right? I don't know who she is.
It doesn't matter at this point. The only reason I brought that to bear was to illustrate exactly the issue with these sorts of discussions now, and why Trump is getting so much support. Is that the average politico, the average pundit on the political left hasn't even is going to appear on Piers Morgan, which is favorable, right? That's fertile ground for the political left ideologically, and to not even be able to give like a 30-second elevator speech of what happened in the case that's so important, while we got people in Congress doing basically victory laps about this conviction. It's just that is a sign of the times, right? Jonathan Turley had a good piece on his website, jonathanturley.org. The title of this article, and we're not going to spend too much time on it, but title of this article is "Buzzkill: The Trump Conviction Presents a Target-Rich Environment for Appeal." Of
it
course,
does.
I think you and I both agreed on that. I think, my asterisk on that is that, the appeal takes time, right? And so it reveals that, um, if he is vindicated upon appeal, Norm, that the process, as everybody has been pointing out, was indeed the punishment. Now, I know that that can be a pretty reductive way to look at the appellate system. Nice big box.
This, my friends, is a copy of the trial transcript in People of New York versus Donald Trump. I don't know whether I'll have time to read it, but it arrived yesterday. Anybody want to make a very substantial contribution to provide me with time to read it? I'll take it. But I am persuaded that he falsified a public record. I'm less persuaded that he did so feloniously. So to me, the jury system worked. Now let's see what the appellate court has to do. I'm intrigued by the politicization of the verdict, and I guess that's what happens in a high profile case. I know it's what happens in a high profile case. I've seen it happen before. But let's move on. What you got? Our girlfriend.
I'm rounding this out. Fawny. The Court of Appeals is going to hear the argument about her disqualification on October 4th, Norm. So think about how far off that is. So that basically guarantees that the Georgia racketeering case against Trump will not occur before the November election. And then the companion story to this out of the New York Sun and by our guy, A.R. Hoffman, is this: June could be Jack Smith's cruelest month as both of his Trump cases are in danger. This one talks about the presidential immunity doctrine as well as the appointment issue with respect to Jack Smith as special counsel and whether he was properly seated as special counsel. Both of these issues, I think, are coming to bear in the coming days, or at least there will be at least 4 arguments forthcoming on these before the respective courts.
A.R. Hoffman is our man. He is obviously Pulitzer Prize winning material, in my view.
I feel like such a fanboy, but I mean, like, what else am I supposed to say? This guy does incredible reporting. He has a command of the law and the context. So good for him.
So bad news for Owen Shroyer last night. You will recall that I represented Owen of Infowars in his January 6th related prosecution, and was very critical of the use of his, what I called, protected speech in his sentencing. He was sentenced to 60 days. We took an appeal to the D.C. Circuit Court of Appeals. It dismissed the appeal. And then Bob Barnes and his office took the certiorari petition to the United States Supreme Court. I was simply tapped out and unable to do more for the funds on hand. And yesterday, the Supreme Court denied cert. And so I can't say I'm surprised. I'm depressed by it. The issue was that Owen trespassed, and his sentence, the government argued, was based in part on speech that Owen uttered about the election days before the election, on the day that he trespassed, that was arguably relevant, and thereafter. And it struck me, and still strikes me, that the use of otherwise protected political speech to enhance a criminal sentence is wrong. Now, the First Amendment says Congress shall make no law abridging freedom of speech. There are all sorts of laws that abridge freedom of speech. You can't engage in criminal conspiracy. You can't incite violence. You can't threaten people. You can't engage in defamation, and so on and so forth. But if you can't go to a march and utter political slogans, if you can't encourage people to attend a march days before and utter political slogans, if you can't utter political slogans about a march afterwards without those words being used to increase your penalty for the crime of simple trespass, I think there's something wrong there. And I think the Supreme Court missed an opportunity to help draw a bright line protecting political speech in divided times. So that will end the case for Owen Shroyer. He did his 60 days. He's got the misdemeanor conviction. He's on supervised release now. He will soon finish that period of supervision and be a free man. And his case will not stand for the proposition that we hoped it would stand for. That is, that protected speech is always protected speech.
Jules says, "How or why did Owen lose?" If I'm not mistaken, Norm, this was part of a catalog of rejections, right? So we don't have any dicta or any justification for them failing to take.
Yeah, Jules, the way the process works in the United States, the federal courts are a three-tiered organization. There are 94 judicial districts or districts in the United States, and those all have trial courts. And those are called district courts. Owen was pled guilty and was sentenced by a district court in the District of Columbia. We felt that the reasons the court gave for its sentence were substantively unreasonable and in violation of the First Amendment. So we asked an appellate court, a circuit court of appeals, to hear Owen's case. It gave a reasoned response in its rejection, saying because he was sentenced to less time than the plea agreement called for as a maximum, he had waived his right to appeal. Our argument was you never waive the right to challenge a misapplication of the First Amendment, and we argued that that was substantively unreasonable. The D.C. Circuit Court of Appeals just didn't listen to that argument. So Owen took it to the United States Supreme Court. Now, the United States Supreme Court receives thousands of petitions for certiorari, petitions to review appellate court cases each year. And they typically decide whether to hear them or not en masse, meaning when they reject your petition, all it says is denied, and you don't know the reasons. Sometimes the court will like an issue, but they won't like the way it's presented. They want to, or they may wait for a different issue, or they may not like the advocates. I had a slap at me by the Supreme Court earlier this year in the United States versus Jake Lang. Lang, Fisher, and another filed petitions for certiorari to challenge the use of the official 18 United States Code 1512 obstruction of official proceedings statute in a J6 prosecution. The court granted certiorari, but not to my petition. They granted it to a guy named Fisher, and they did so in part because that team relied on a well-known Supreme Court advocate and university professor. And the court was probably persuaded that he was well known, he was a professor, he was less ideologically driven than me, and they chose his petition rather than mine. I'll never know why. They granted the Fisher petition. They'll decide it later this month. Mine remains active on the court docket with no ruling one way or another. So the news is the Supreme Court does what it does, as it does, for reasons that it'll explain when it wants to, and doesn't, and won't when it doesn't. And when you're done with the Supreme Court, you're done. And this goes to this business of institutionalism that I mentioned earlier. My view of the courts are lawyers take their clients there. Their clients have interests. Lawyers' responsibility are to understand the interest, advance them within the rule of law, try to win your trial. If you don't, take an appeal. If you don't like the results of the appeal, go to the Supreme Court. If you don't like what the Supreme Court's done, you're done. And so I'm not going to attack the Supreme Court as filled with left-wing lunatics and losers who don't care about the First Amendment. I just know they didn't care to hear Owen's issue. I still think we're right, and I intend to raise a similar issue in the Proud Boys appeal eventually. So big news in Austin over the weekend. I'm not a regular viewer of Infowars, but I saw on Twitter that Alex was on the air predicting the end. And I spoke to one of the lawyers in the case saying, what's going on down there? And apparently one of the stakeholders in free speech systems was apparently refusing to provide additional financing. And Alex was on the air, and somehow this became in his mind, a threat that the FBI was coming in to shut him down. And apparently Steve Bannon and others were calling for others to come to Alex's assistance. By the end of the weekend, apparently the financier had backed down and Infowars remains in business. But it is in imminent risk of liquidation. Infowars is actually Free Speech Systems. That's the name of the company. And Free Speech Systems sought protection in the bankruptcy courts of Texas, incident to some judgments in Texas and Connecticut. I was the lawyer in the Connecticut case. And people have asked, how is it possible that this case went to bankruptcy before the Connecticut appellate court decisions were decided, because Alex's case is still on appeal in Connecticut? And the answer is that Alex agreed to proceed in the bankruptcy courts in the absence of challenging in the absence of a stay, just to get the case on, just to get it moving, and just to get on with his life. But now the voluntary portion of the bankruptcy, in other words, the attempt to reorganize with a restructuring agent and a credit and the approval of the creditors committee, appears to be on its last legs. And the federal bankruptcy judge suggested that it may come time to convert this voluntary bankruptcy into an involuntary liquidation, and that ruling could take place as soon as this week. Now, as soon as next week, excuse me. I know that Alex has vowed to never be silenced. I know that he has vowed to keep his voice alive, if necessary, through some other vehicle. But I think the end of an era is upon us, and that Infowars will soon be on the chopping block.
Here's
Ladies and gentlemen, we have had the FBI and the CIA and the deep state trying to shut us down for years. It's come out in Congress. It's been testified in court. Undercover groups have caught FBI, CIA on video admitting it. They are trying to take us down. And in all this lawfare the Democratic Party has run, they've been on record saying they want to shut us down. But we've been so strong and stayed on air so long that when we are facing our final battle and the system is trying to close the doors here, some people are like, whoa, is this really happening? Yes, ladies and gentlemen, this is all happening. Here are 3 articles: AP, Reuters, CBS News. Actually, I got 4 articles here. Bloomberg. They're all right here with the headline: Sandy Hook families ask for Alex Jones Media Company's liquidation on the 14th.
So just to explain that one more time, Norm, the families have standing to file for liquidation based on a violation of what?
No, I might rephrase the question, and I'm no expert in bankruptcy law. I'm not in the bankruptcy case. I talk to the bankruptcy lawyers to get my bearings on this. So don't take any of this to the bank, so to speak. But Alex and his companies sought relief in the bankruptcy court, and they sought an opportunity to restructure and to negotiate a reduced payment to the families on a structured settlement,
and we covered
other creditors. And the creditors committee, which is comprised in part of the Sandy Hook families, have rejected the efforts of Jones to reorganize and settle the case. And so it's their right to do so. And if they reject that and they have a judgment that is unsatisfied, they can request that the bankruptcy be converted into a liquidation, so that they can seize whatever assets are not exempt under law and satisfy their judgment that way. I think there are those among the parties who've sued Jones whose real goal was never financial, but whose goal was to take down Infowars and to try to silence Alex Jones. From their perspective, I suppose the good news is they can take down Infowars, but they'll never really silence Alex Jones. He will find a different forum, and the fight to collect from him will go on for a good many years.
Yeah, that to me makes a little bit of sense. I mean, one must necessarily believe that there is not a prevailing financial motive to believe that this is what's going on. And to me, that is what is most obvious here, is that the only justice that at least one or more of these families would see done is a complete removal of him from the airwaves.
Well, I mean, I attended the trial. Obviously, it was a bitter experience for everyone involved. And the family's position is they were devastated emotionally and financially as a result of misinformation that was spread on Infowars, and they want Jones held accountable. There are those who had larger agendas. Elizabeth Williamson from the New York Times wrote a book, I think, called Sandy Hook and the War on Disinformation. And there are many who believe that Alex Jones is the test case for the war on disinformation. And certainly some of the law that was developed in that case, even though it arose in response to a default, but the use of like terrorism experts and stochastic terrorist theories, that is the spreading of lies and misinformation online. You saw that used a little bit in against Giuliani in the Fulton County case, and I think you'll see more of it in the years to come. The appellate court in Connecticut heard argument on our appeal of the verdict. I believe that was in January, and we'll get a ruling any day now. So who knows what the case will ultimately stand for. The bottom line, however, is that by month's end, Infowars is likely to be no more, and what becomes of Alex Jones will remain an interesting story.
Wow. So I mean, that's a pretty aggressive timeline, all things considered, I think.
Yep.
One thing I wanted to point out here, we have at least one of our viewers over on the Green platform is interested in this, and I saw this on Reuters this morning. FDA panel to review psychedelic drug MDMA for the first time. So this is stuff used in the treatment of trauma, PTSD in particular, and I think the primary demographic are those that were dropped into hostile war zones in the Middle East, those of our veteran community, and assisting with essentially rewiring those neuron firing systems to allow individuals suffering from PTSD to find different sort of neural pathways to deal with trauma.
Well, and I think is it Tim Polan, Polan, who's written, or AAN, who's written persuasive books on the use of MDMA and other drugs of that sort to treat psychiatric illnesses. So it's encouraging to see the FDA take an open mind.
Well, there's a big there's the Pearl Psychedelic Research Institute here in the mountains of North Carolina, Asheville, and that's how I know a little bit about this. But there's been a lot in the last few years, pretty aggressive advocacy at the policy level on this stuff, and really good results and yield from clinical trials. So I'm hopeful about this. I'm glad to see this, but I'm also sort of waiting with bated breath, because we know that the FDA approval process is not something to just assume will be done quickly or cheaply.
I want to comment, Maury, Alex and Trump suffer from the same disease. They both use hyperbole casually and upset too many. Truth, there is a value to truth. And how much, hyperbole, when it crosses a line from overstatement to falsehood, when it crosses a line from opinion to assertion of fact, when those assertions of fact are false and harming other people, they're actionable. Whether you be a president or a broadcaster, I like to think in the marketplace of ideas, integrity matters, and the litigation process helps sort it out. I believe in the Alex Jones case, the litigation process failed. The default was entered in error. I would have liked to have seen that case resolved on the merits. It wasn't, and who knows whether there'll be another trial someday. If there is, I won't be trying it, I can tell you that. But in any case, here we are, and we've talked our way through another half an hour of your lives, for which we thank you.
Indeed, we have. Our goal is to get over 2,000 subscribers on the Red platform. We'd like to get over 1,000 on the Green platform. I'm going to stop using the names of those respective channels, because I do believe, Norm, that there is some sort of deceleration effect while we're simul streaming to these respective platforms, because they are in competition with one another. So just as the robot AI algorithms will track and find those things, please, wherever you're coming to us from, whether that be on the Green platform, the Red platform, or the Black platform with the big Roman numeral, we'll call it, in the middle of it, please make sure you are subscribed to Law Pod Daily, Law and Legitimacy on the Green platform. We are live every morning at 8 a.m. Eastern Time, Monday through Friday. You can also find the audio-only versions of these streams on Apple Podcasts, Spotify, Google Play, Overcast, wherever you find premium podcasts. And please make sure you're subscribed over there. Leave us a comment and 5 stars. Norm, what do you got?
AMF, Yo-Yo, I'm on my way to court. Closing arguments are within an hour. So
Awesome. Well, good luck with that. AMF, Yo-Yo. See you later, everybody. Thank you for being here.